Welcome everyone to our webinar today on employment law. We have closed caption below if you need it. We have Brandon Klippinger here today with us to talk about the things that sometimes keep us awake at night. You know, are we doing the right thing? What are the rules? How are we managing the knowledge that we need for our businesses and our own employees? So I will thank you again, Brandon, for being willing to do this for our membership. One of the biggest values that we have is that our membership is so supportive of one another, and it's been a really, really beautiful thing to see as we've come together as a group over the last 3.5 years. So I will pass it on to you. Thank you again for being here to share this information with us.
Thanks so much. And it's my pleasure to be here. So thank you for having me. My name is Brandon Klippinger of Klippinger Employment Law. And today I'm going to be walking us through a little session I put together called Employment Law 101. And it's to cover a number of the topics that I see in my daily work that affect both small, medium, and large size employers as they are conducting their business, things that can be prevented or thought about ahead of time, and how to resolve some issues that come up. Just a little notice that what we're talking about today is just general information, is not to be taken as legal advice. So this is our agenda for today. We're going to start with a little bit of a conversation about what employment law is. And then we're going to go through a number of topics that I see come up with some frequency. Employees versus independent contractors, wage and hour law, non-competition, non-solicitation agreements, discrimination in hostile work environments, and the Massachusetts paid family medical leave. And then we're going to make sure to leave some time at the end to have some discussions, and there's a Q&A field. And if you have any questions as we go along, or if there's something I didn't cover, please do feel free to put it in there and we can talk about it at the end.
And I'll just do a quick jump in, Brandon, because I failed to remind folks that if you have a question, please pop it into the Q&A, as Brandon just said. And during the presentation, Brandon is going to ask you some questions as we go along. And so for those questions, put your answers in chat, please, so that we can all see them. And then for any other questions that you might have over the course of the presentation, please pop them into the Q&A feature. Please remember that this video is going to be shared on our YouTube channel. And so if there's anything that is sensitive, just submit your question anonymously, which is an option that you have in the Q&A. Thank you so much. Sorry to jump in.
No, thank you. And so what does employment law encompass? So it really covers the gamut of what employers and small companies and larger companies do on a daily basis. So employer handbooks and policies, how you pay your employees, how you hire and separate employees, how you manage performance, agreements that you might have your employees sign, leaves, disability accommodations, investigations, and discrimination and harassment, which we want to, of course, avoid. So as Thais mentioned, I do have a few prompts that I think will be helpful just to have us engage with what this sort of work is. And I find it's a good way to learn and operationalize. So the first topic that I want to talk about is employees versus independent contractors. I see this a lot, that it's sometimes difficult to know what the difference is between the two or when one is the other. So this is a little prompt. So which of the following are true about independent contractors? A, the law allows employees to be classified as independent contractors temporarily while the employer decides whether to hire them full time. B, an individual is legally an independent contractor so long as both the employer and individual agree so in a signed contract. C, if you designate an individual as an independent contractor, you are automatically relieved of any legal duty to pay them overtime, sick pay, or workers' comp. Or D, none of the above. So no pressure, but if you're feeling brave, no judgment also, but feel free to drop your answer in the chat. If you think you know the answer to this question, something that you may have dealt with in the past, All right, great. Thanks, Shanna or Shauna, I appreciate that. I'll give a few moments to see if anyone else wants to volunteer. We have 2 for D. Looks like the Ds are taking it. And yeah, everyone can pat themselves on the back. That's correct. The answer is D. So that means that A, B, and C are not true, that just because someone is engaged on a short-term basis, that they can be classified as an independent contractor. Even if both parties want to be an independent contractor, that doesn't make it so. And just because you've designated someone as an independent contractor doesn't make them one. So what does make an individual an independent contractor versus an employee? So Massachusetts has a 3-part test for determining whether an individual can be classified as an independent contractor. We call this the ABC test. And under this test, all 3 of these criteria must be satisfied. The individual must be free from employer's direction and control. It must be a service performed outside of the usual course of the employer's business. And the individual must be engaged in an independent trade, occupation, profession, or business. And so when I try to think of like a classic example of what this might be, like if you're like a marketing firm and you have a pipe that's leaking and you need someone to come in and fix it, a plumber would be an excellent example of an independent contractor. You're not going to be in a position to tell them how to go about doing their work. Their work is outside of your normal industry of marketing. And a plumber typically has many clients, many customers, and they have their own business. And so that individual is going to be very comfortably classified as an independent contractor. If you've been following the news, you know that there are some categories of workers that have proven a little bit more difficult to classify, like we have in the gig economy, Uber drivers, Lyft drivers, those sorts of positions where there's some tension as to whether or not they might be an independent contractor. But in the plumber sense or an electrician, it's a pretty classic independent contractor. But if you're just experiencing a surge in your business, for example, and you need someone on a short-term basis, and they're doing something that's within the field of your business, they're going to be most likely classified as an employee and not an independent contractor. And the reason, why do we care about this? Why does it matter? The reason is that if someone's classified as an independent contractor, then they normally don't receive all the protections that an employee receives. They're not getting paid sick time, they're not getting vacation time. You might not be tracking their time to ensure that they're paid overtime, you're not withholding taxes. And so all of these secondary consequences, called them a secondary violation, can result in liability to the employer. So it's important to be careful about who you classify as an employee versus an independent contractor. If there are any questions about that, feel free to put your question in the Q&A field and we'll be sure to get to it later. So now we're going to move on to topic number 2, which is wage and hour requirements. So we have another prompt. I love the audience participation from the last one, so I'm hoping we can keep it up. Which of the following are true about overtime laws? A, if an employee earns over $85,000 a year, then they may be paid a fixed salary without receiving overtime pay. B, instead of paying overtime pay, a company may provide an employee comp time to use in later pay periods. C, an employer can discipline an employee for working overtime without permission. D, none of the above. I'll give folks a second to think those over. We have 1D. B. Give folks a few more seconds. B. Okay, so the answer to this one is actually C. So it sounds like no one thought that just because you pay someone over $85,000 a year that they can be paid a fixed salary without receiving overtime pay. And that's true. There's specific tests that we use to determine whether someone is exempt from the overtime requirements. We'll talk about that in a little bit. Instead of paying overtime pay, a company can provide an employee comp time to use in later pay periods. Now, in some government positions, you can do this, but for private companies, this is actually not allowed. If you're within the same work week, then you can, if someone works long one day, then you can pay them less. I mean, have them work less the next day to make up for it. But as we move away from that work week, you're no longer allowed to use comp time in later pay periods. So your only option is to pay them overtime for that work. But C, an employer can discipline an employee for working overtime without permission. So if you set clear boundaries about when an employee can and cannot work, then you can discipline them for working outside those boundaries. You still have to pay them the overtime. The laws say that if someone works more than 40 hours in a work week and they are overtime eligible, then you have to pay it for them, but you can discipline them. And I see that there is a question, and looks a little bit lengthy. So what I'll do is I'm going to keep on moving along, and then maybe once we get to the Q&A, we can talk about it a little bit more. So just for general, so we all have the same base understanding, the Fair Labor Standards Act is a federal law, requires the payment of overtime that's 1.5 times the regular rate to employees who work more than 40 hours in a work week, unless they fall under one of the law's exemptions. So exempt employees, so that means they're exempt from the Fair Labor Standards Act overtime requirements, they may be paid a fixed salary. I mean, you can pay them the same amount every week, regardless of how many hours they work. But non-exempt employees, so those who don't fall under one of the exemptions, then they have to be paid overtime if they work more than 40 hours in a work week. And we have very prescribed regulations from the DOL as to who falls under these exemptions. And misclassification can lead to financial liability, treble damages, which is a legal way of saying triple damages. And that's where the federal law and the state law in Massachusetts interact, because under Massachusetts law, if you don't pay wages on time, then you're liable for 3 times the amount owed. So if you don't follow the federal overtime rules, then you get the treble damages penalty in Massachusetts. And here are just some examples of some roles that might qualify for the overtime requirements. That might qualify for the exemption from the overtime requirements. Each exemption here has a very specific test. And so I don't want to give the impression that if someone is automatically in these roles, then they automatically don't have to pay them overtime. But these are roles that we see that do fall in this exemption from time to time. So in order for a role to fall in one of these exemptions, they have to meet the duties test, and they have to be paid at least $684 a week. And if they work less than their full schedule during the week, unless it falls on another one of the specific exemptions, you can't dock their pay. Otherwise, they're not being paid a fixed salary. So some important takeaways for overtime is if you're paying an employee who works more than 40 hours in a work week in a fixed salary, be sure they're correctly classified as exempt. You're going to carefully monitor and record and pay for all time worked by non-exempt employees, including time worked remotely and outside ordinary business hours, and set clear expectations about when an employee is and is not expected to work. Now, I'm going to go ahead and look at the chat and make sure that I answered this question. I'm a photographer and hire second shooters to work with me at large events and hire someone for 8 to 10 hours a week to edit and tone my pictures. They set their own hours for the editing, and everyone I hire has a business in their own right. They're all photographers. Can I consider them all independent contractors? They all have their own clients and lots of other work. That's interesting, and it might require a conversation beyond the scope of this presentation. So I'm happy to talk to you about it further. If what they're doing is outside the scope of your business, then maybe, but just because someone is an independent contractor in one context doesn't mean they're not an employee in another. So I think that's something I want to have a little bit of a further conversation about before giving you a definitive answer. I'm happy to talk about it more after the call. So non-competition and non-solicitation agreements. So we're going to do another little prompt. Which of the following are true? Non-competition agreements are not enforceable in Massachusetts. Non-competition agreements are enforceable in Massachusetts if they satisfy certain legal requirements. Non-solicitation agreements are easier to enforce than non-competition agreements. Both B and C and true, or none of the above are true. And there might be some folks who don't know what either of these agreements are, and that's totally fine because we're going to get to it soon. So any brave souls want to answer? D, the one for D. Thank you, Charity. Okay, Charity wins the prize. Both B and C are true. A is false. So let's talk a little bit more about that. So non-competition agreements. A non-competition agreement prohibits a former employee from competing against their employer. Since 2018, Massachusetts has enacted a law that specifically governs non-compete agreements. And there are many requirements in order for these agreements to be enforceable. So it includes the time that they're presented to the employee, the content of the agreement, what you have to give in exchange for the agreement, the context of the agreement. There's a lot of requirements regarding non-competition agreements. So while some of these areas, I think they all benefit from the input of a lawyer, this would probably be one of the most challenging to tackle without the assistance of legal counsel, because they are very complicated and statutorily governed. But they are enforceable if they are appropriately drafted to within the bounds of Massachusetts statute and to protect the legitimate interests of an employer. I often find that people, they have the piece of paper and it doesn't feel like it can really has that much power to it, and they might disregard it. But I assure you that these can be enforced. Non-solicitation agreements are a little less restrictive than non-competition agreements. Non-solicitation agreements prohibit a former employee from soliciting customers or employees of a former employer. And these are generally enforceable if drafted to protect legitimate business interests. So these agreements do not have all the statutory requirements that the non-competition agreements have. They typically are in writing. They still benefit from the use of careful drafting. But these are typically targeted towards specific customers that you want to avoid your current and then potentially former staff from soliciting away, so taking away your business, and also from what we call the poaching of employees. So former employees who have a relationship with other employees might have gotten a good gig elsewhere. Through a non-solicitation agreement, you can prohibit them from recruiting your employees for a limited period of time after they leave. So now we're going to talk about discrimination and hostile work environments. So which of the following are true? Employees often prove discrimination by comparing their treatment to similarly situated employees. Any hostile work environment is illegal. Anti-discrimination laws only protect historically marginalized groups. Oh, I went too far. So the answer is A. For those who are paying close attention, the answer is A. Employees often prove discrimination by comparing their treatment to similarly situated employees. I find that a common misconception is the belief that any hostile work environment is illegal. And the way the law works is that a hostile work environment is typically illegal when it is a hostile work environment that is based on discrimination towards a particular protected class or particular bias. And I have a list of the most common ones here. So these classes are legally protected from discrimination. They include race or color, national origin, sex or gender, which includes sexual harassment, sexual orientation, gender identity or expression, age, which goes in one direction, over 40, disability, genetic information, union membership, military service, and pregnancy. So when we talk about a hostile work environment being illegal, it needs to be a hostile work environment that's motivated based on one of those factors. So someone who treats everyone terribly, you're going to have a very hard time successfully finding them liable for an unlawful hostile work environment. But an environment where people of a certain race or gender or sexual orientation are treated inappropriately, then you will have a viable claim. And another common misconception is that anti-discrimination laws only protect historically marginalized groups. And this is not true. All of these, if an employer is making an adverse employment decision or creating a hostile work environment towards anyone because of any of these bases, then that will constitute unlawful activity. So if someone's being treated differently because they're a man or because they're in a race that happens to be majority, it's still unlawful. And I do see those claims come up from time to time. It's also unlawful to retaliate against an employee for complaining about discrimination. It's very common that an employee will bring a discrimination complaint either internally within the organization or to the Massachusetts Commission Against Discrimination or Equal Employment Opportunity Commission, and that underlying claim is actually not meritorious. They don't have a good complaint. However, the employer, upon receiving that complaint, might take steps to retaliate against an employee. And I can tell you, if you've never had an employee who's accused you of discrimination, you have to continue to work with every day. It is very challenging, but it is important that you not retaliate against such an individual, because retaliating against an individual can provide a separate basis for liability. So even if the underlying discrimination claim does not succeed, the retaliation claim might. And of course, there's also the chance that both succeed. So that is also something to keep in mind. Discrimination, the anti-discrimination laws not only impose duties not to take certain actions, not to treat people inappropriately, not to discriminate, but they also impose certain affirmative obligations on employers to accommodate disabilities and religious beliefs. And we've seen this a lot recently with the pandemic and people wanting exceptions to employers' vaccine mandates. I can tell you that as an employment lawyer, we've been receiving these sorts of complaints unrelated to the vaccine mandate on an ongoing basis for years, but these have really hit the media en masse with the vaccine mandates. And so for disabilities, employers must make a reasonable accommodation for the disability unless such accommodation would pose an undue hardship or the employee would continue to pose a direct safety or health threat. And for religion, it's a little bit of a lesser or a higher threshold for an employee to successfully prevail on a claim for religious discrimination for failure to accommodate, because employers must accommodate religious belief unless it poses more than a de minimis cost to the employer, which is less than an undue hardship. And so we've seen a lot of this with vaccine mandates. It's something that employers need to really consider on a case-by-case basis. I mean, aside from the employee mandate, the vaccine mandate, there's a lot of case law, there's a lot of regulatory guidance on what must be accommodated. And some of it is gray area. And we find that the best results occur when an employer does engage in an interactive process. So first, the employer has an obligation, they have to engage in an interactive process to attempt to find a reasonable accommodation. And the more the employer can engage in that in good faith, the better the chances of success are. So if an employee presents to you with a medical condition and a proposed disability, employer does have the right to ask for medical documentation from their healthcare provider to document what the condition is and how it might affect their work. And then the employee will oftentimes request a specific accommodation. The employer does not have to provide the specific accommodation that was requested. And so if an employee asks for accommodation A due to a medical condition, and the employer realizes that that is not going to work for them, but accommodation B would work for them, and it seems would also address the employee's condition so that they could perform the essential functions of their role, then the employer could present to them accommodation B, and it is then up to the employee to decide whether they can accept accommodation B, if not, why. And then we have a bit of a dialogue and hopefully end up in a place where we have a reasonable accommodation that meets the requirements of the employee as well as the requirements of the employer. So here are just a few tips that I have come across to avoid discrimination claims. One is consistency. We find that if you have established protocols for handling issues, such as your steps for corrective action, progressive discipline, when employees are able to take time off, when employees, how employee comp decisions are determined, how increases in pay are determined, how performance reviews are done. The more consistency you have, the more difficulty an employee will have in showing that they were treated differently based on a protected class, because you have an established process for handling those matters. And as long as they were handled consistent with that process, then you're going to be able to provide that as evidence as to why they were not treated differently based on their membership in protected class. Secondly is respect, which I know seems obvious, but going to my earlier point about hostile work environment, no, not all hostile work environments are unlawful, but it is true that unlawful hostile work environments are more likely to cause employees to complain, whether rightfully or wrongfully, as a matter of law. And to the extent you're creating a place where employees feel respected and want to be, it's less likely that they're going to allege discrimination. And even if an employer is not acting out of discriminatory animus, I find that it's often the case that an employee who does perceive that they are being treated poorly is often bringing with them some lived experiences of having been treated differently, particularly if they are an historically marginalized group. And so to avoid them jumping to the assumption that they are being treated adversely because of their protected class, it's best just to treat everyone respectfully from the get-go. Prompt and candid feedback I find is incredibly useful. If issues aren't addressed in the moment, and frankly, then it allows issues to fester, and those often result in some adverse action to the employee down the line, whether it be immediate termination because the employer can no longer handle whatever the sort of issue is, or a failure for a promotion or a negative performance review. Whereas if prompt and candid feedback is given as to why a particular action is being taken, or why performance or conduct is not appropriate or not meeting your expectations, then when it does come time to make that decision, it's clear why the decision is being made, and it's known it's not for any unlawful reason. Thoughtful and contemporaneous documentation. This goes hand in hand with prompt and candid feedback. To the extent you can document why you are taking a step that is adverse to the employee, or if the employee does something either in terms of performance or misconduct that does not meet your expectations, then documenting it in real time will be useful down the road in litigation. In litigation, we rely a lot on documentary evidence. Verbal conversations, while they come out through testimony, are a little less reliable than what's written down on paper. And I say thoughtful because there's also a tendency, particularly the more technology we have, to put things down in writing that are actually unhelpful to us in the event of litigation. Emails, instant messages, text messages, they might all be discoverable, and oftentimes are, in the course of litigation, meaning that if you do end up in litigation, the other side, the plaintiff, is going to be requesting that documentation, and you have to hand it over. And so I would advise, where possible, to be less casual in conversations that relate to employee performance or conduct in your electronic and written communications, because they have a longer shelf life than many people realize. So you want to be thoughtful and smart about documenting what you do want to be preserved, and refraining from saying anything that you don't want to be preserved. Address and resolve company mistakes. Mistakes do happen, whether they relate to discrimination or just anything we've really talked about, whether it be a missed payment in the past, something that needs to be fixed. I find in many cases employees don't want to sue, particularly their current employer. So if you can resolve it, you can address the issue then and there. It doesn't mean there might not be some legal liability, so you might want to talk to a lawyer about it. But taking ownership of mistakes, I find, often goes a long way. Former employees, however, oftentimes have less of a barrier to seeking legal redress against their employer. So to the extent you can address issues early on so it don't become issues later, it's better. Cultural competency and DEI training is always great. We all have blind spots, myself included. And I think as a society, we're always evolving in terms of what's acceptable and appropriate. And so to the extent we can all stay on par with expectations and be knowledgeable of what people who might come from different backgrounds from ourselves might be expecting or how they might perceive things, I think that's always helpful. And then whenever you get into an issue that's beyond your scope of knowledge or expertise, you can always partner with legal counsel. And so my last topic before we turn to our conversation is the Massachusetts Paid and Family Medical Leave laws. And so this recently went into effect, and covered individuals are eligible for 20 weeks of paid leave for their serious health condition and 12 weeks of family leave to bond with a new child or care for a family member with a serious health condition, up to a maximum of 26 weeks in a benefit year. So this is a significant amount of leave. And unlike the ADA, there is no sort of reasonability analysis. This is leave to which employees are entitled. So it's important to respect Massachusetts Paid Family Medical Leave, follow the process. If you're a smaller organization, it might be that you have your program administered through the state. If you're a larger company, you might have a private plan, or any of those companies can have you can obtain a fully insured plan through a number of third-party service providers. But this time is going to be protected time. They are going to receive some pay for it. And an employer that takes adverse action within 6 months of an employee taking advantage of this benefit is presumed to have engaged in retaliation. This is one of the rare cases in which an employer in a lawsuit bears the burden of proof. So if an employee does sue an employer for violation of Massachusetts Paid Family Medical Leave, it's going to be the employer who's going to have to show by clear and convincing evidence that they terminated that individual's employment or took any other adverse action, whether that be a decrease in pay, denial of promotion, et cetera, for reasons other than they're taking a medical leave. And if you're a larger employer, then you are going to be responsible for making part of the contributions for this program. This program is funded by a payroll tax. And if you're a smaller organization, then the employee is going to bear the entire burden for financially for making these contributions. And that is the end of my prepared discussion. And I know there have been some questions that have come in. So Thais, I don't know, should I just go to the Q&A section or I see some in the chat, whichever is the best way you think of approaching this.
We moved them over. So how about I read them out to you?
Okay, that'd be great.
And then I can keep track of what's coming in.
And I think we already did the photographer question, and
yes,
to speak to them afterwards.
Perfect. And so folks, if there are any other questions, please pop them into the Q&A and we'll address them as we move through. Here's the next one. I'm actually pregnant and my company has been amazingly supportive of me taking leave. However, my boyfriend has been getting told by his boss that he's really putting them in a bind by taking 3 months off and asking, do you have to take that long, etc. I'm not sure that counts as discrimination because he hasn't done anything but talk about it, but wondering if something were to come up, would my boyfriend be covered under the pregnancy for discrimination?
I think, so just the fact that his employer has made those statements is problematic. And under Massachusetts Paid Family Medical Leave, I mean, he's entitled to up to the 3 months to take care of a new child, or to bond with a new child. So, if nothing more comes of it than that, then I don't know that he would have a viable claim, because in employment law, we're often looking for, or what is actually actionable as an adverse employment action. So that means the employee is actually adversely affected in some way, meaning that they're terminated, or they're not they don't get a pay increase. It can take really a variety of forms. Just the comment on its own, I think you would have a difficult, it's not appropriate. I don't know that it'd be enough on its own to file a retaliation claim, but I think, it's worth monitoring. And if your boyfriend is treated, if there is an adverse employment action later, shortly after this, it's certainly something worth taking into consideration.
Thank you. Here's a related question. How does this work for small employers under 3 people? If you have 1 or 2 employees and they take paid family leave, are you required to keep the job for them, even if having no staff would stop the company from operating? Do I hire someone as a part-time contract worker?
Yeah, so in that situation, their leave is protected. So the best option, I think, in this case would be to hire someone part-time, but it would go back to what we were talking before about as a contract worker. You're not going to be able to just engage them as a 1099 if they don't meet that independent contractor test. So it's really just hiring a short-term employee in order to support them. I could take another, if I know this person's anonymous, I'm not aware of any exceptions for an organization this small, but I haven't looked into it before. And so if they want to contact me after, I'm happy to look into it. But I would say certainly for generally most organizations, that time is protected. And I would be wary of going the contract worker route, if by that they mean 1099 and not withholding employment taxes and providing them the normal, workers' comp and that sort of thing.
Perfect. And another related question. If we hire folks part-time to help out as needed, can we 1099 them?
And that goes back to the same issue. So if they are performing work that's within the scope of your business and they're subject to your direction and control, then I again would caution against 1099ing them. They're most likely not going to meet the definition of an independent contractor. So legally, I think there's some exposure there.
Thank you so much. Any other questions, folks? Oh, I think we have another one. What about staffing agencies? Are they not just contractors?
So the way it works with staffing agencies, so staffing agencies, the individuals who work for those staffing agencies, they are getting their employee type protections through that staffing agency. So this isn't the case of someone who is not, who's not covered by workers' comp, who doesn't have a personnel record, who doesn't have health insurance. They're all being provided by that staffing agency. And so when you're contracting with the staffing agency, the understanding is that they are responsible for fulfilling those employer obligations. And I would recommend that your contract with any staffing agencies contains certain provisions that ensures that they are responsible for those obligations. Now, there are certain aspects of your work that you're still going to be most likely a joint employer. For example, if you were to discriminate against a temporary employee that's placed with you by a staffing agency, you can't avoid liability, or you're going to have a difficult time, I'd say, avoiding liability under the anti-discrimination laws just because they are placed with you through a staffing agency. But because of the way the relationship with the staffing agency works, we don't have a case. It's unlikely that we have a case where these individuals don't have workers' comp, aren't being paid overtime. They should be paying those things by the staffing agency, but you're counting on the staffing agency doing those things.
Perfect. Thank you. Anything else, folks, that you want to pop into the Q&A box? Please do so. We'll give it another minute. Brandon, thank you so much again for doing this. This has been really enlightening and so helpful to think through all of these things, particularly I think the 1099 question is one that comes up really, really frequently. So thank you for making those distinctions for us. Much appreciated. And again, folks, if you have any other questions, please pop them into Q&A as soon as you can. And in the meantime, I sent out an email this morning, so you should have received it, folks. If you applied for new applicant grant or inclusive grant, please let me know. We're trying to get some more information from MGCC on when those determinations are going to be made. And I want to make sure I keep the right people informed. So please let me know, even if you think I know or know I know, because I worked on the application with you, please just pop me a note. Looks like we don't have any other questions. Thank you again. This is really great. Thank you for your support to other members. Brandon, much appreciated.
Yeah, it's my pleasure. These are the sorts of things that I do through my daily work. And so if there are any questions that come up after the call, or if you think you have something going on with your company that might benefit from further discussion, my contact information is at the top of the slides. And I'm just happy to be able to present this. So thank you for having me.
Thank you so much. And we will share the slide presentation with folks in the next member email I send out. We'll have the presentation too, and the recording is going to be available on our YouTube channel. So thank you all for being here today.